Hello everybody, thank you for joining us on this webinar, and we're going to be concentrating on the new immigration proposals that are coming into force this year and what businesses will need to do. A copy of the slides will be sent to delegates at the end, so you don't need to worry about making notes, particularly as this will be a technical seminar because there are new routes in, and we thought it's important for clients to know the details of those routes. Also, if you've got any questions, please put them to us and we can answer them as best we can at the end. I'm joined by my expert, Senior Associate Rebecca. Rebecca, can you put on the agenda slide? So we are going to look at some of the new business immigration routes, the changes to the existing routes, what's happening with the COVID concessions, right to work checks, changes to the biometric resident permits, and implementation of the technology in the right to work checks, which has been a game changer, especially for employers. Next slide, please, Rebecca. So there are going to be 3 new immigration routes that the Chancellor has introduced. So these are going to be on top of the current routes, and in particular, as you know, if you want a skilled worker, you have to have a sponsorship license. It's never been so easy to get a skilled worker visa. The threshold of salary is relatively low, the educational level is low, so that is a mechanism that people should be thinking of. I am going to be saying some barbed comments during this process. Rebecca can get you a sponsorship license within 7 days. If you're an asylum seeker from Ukraine, you can't get a visa at the moment. So some of these routes are in. You can make them work for you and what your organisation wants to do in terms of its values. So, as you know, at the moment you have the intercompany transfer and the Global Business Mobility Visa, which comes in the spring, is a sponsored route, but it's looking at changing the ICT and widening it up, and Rebecca will talk about that. Then we have this scale-up visa, and all of these visas is about getting this really high talent, innovation, startup companies in. So scale-up visa will be businesses that are showing rapid growth over 3 years, and it would be an unsponsored route if you wanted to go and work for those companies. Again, Rebecca will be discussing about what measures you have to meet, and they're not particularly high measures. And I will be talking about high potential individual visas. So this is really if you want the next Einstein, Steve Jobs to come and work with you. I would just sort of say that at the moment, if you have a student, they are relatively easy to sponsor both whilst they're at university and on the graduate scheme because of the widening of the rules. The government has not yet published detailed guidance, but it's important that clients are aware of these routes because some of your industries will perhaps see a much better benefit for some of them, particularly hospitality, which Rebecca will talk about on the youth schemes. Rebecca, over to you.
Hi, so firstly, we will be discussing the global business mobility route. As Monica said, this is the Home Office's expansion of the current ICT and sole rep routes. The ICT visa, as you probably know, is to bring over overseas workers from linked entities. And the sole rep visa is for one individual from an overseas business to come to the UK with view to establishing a branch or a subsidiary. The global business mobility route will provide greater flexibility for overseas businesses who are looking to establish a presence in the UK or bring workers to the UK. It's essentially a rebranding and a combining of the ICT and the sole rep routes, which are the only routes currently allowing global businesses to bring workers to the UK. So what we know about the GBM route is that there will be 5 new categories of workers. All of these roles must be sponsored. There will be no English language requirement as with the current ICT route. However, the existing requirement for an overseas worker to be employed with the entity for a minimum amount of time will remain. This route, again, with the similar to the ICT, will not lead to settlement, but once in the UK, they will be eligible to apply for a settlement route such as the skilled worker visa. The jobs must be at an appropriate skill level, and there will be a minimum salary threshold. What we don't know, following on from that, is that we don't know the minimum salary threshold, and we don't know what the minimum skill level will be. With the ICT currently, the worker must have at least a degree, which is what's called RQF level 6. We don't know whether it's going to be maintained at that minimum or whether it will be the same as with the skilled worker, which is the lower threshold of an A level. We don't know how sponsorship will actually work in each category, and we still don't know the exact date that applications will open. So with the GBM route, there are kind of 2 subcategories. There are visas that will require there to be a UK presence, meaning there is an established organization in the UK, and then there is the category of there not being a requirement for there to be an entity in the UK. So firstly, companies that have a presence in the UK will be able to bring over senior specialist workers, graduate trainees, and secondment workers. Secondment workers apply in both categories, as you can see. So with companies that do not yet have a UK presence, this includes bringing over secondment workers, service suppliers, and UK expansion workers. So those individuals with the purpose of coming to the UK to establish a presence. So just a brief summary of each type of worker. Senior specialist workers are those with the requisite skills or senior executives who are required in the UK branch. Graduate trainees, as you probably already know, are those who are on placements in the UK as part of a structured training program. Secondment workers are in the UK for specific purposes, such as transferring knowledge or overseeing investments. Service suppliers are those individuals coming to the UK to deliver a specific service in line with an existing agreement. UK expansion workers are these specialist individuals who are on assignment to expand the business into the UK. So how will this work exactly? So for all categories of workers other than the service supplier and the expansion worker, there needs to be a so-called receiving business in the UK who will receive this overseas worker from the sending entity overseas. There needs to be evidence of an existing business relationship between these 2 entities. So for example, this could be overseas parent companies who are sending staff to the UK to one of its subsidiaries. This could be service suppliers who have existing contracts with UK clients, or again, those on secondment coming to the UK. So just a little bit about the UK expansion pathway under the GBM route. So this is quite a difference to the sole rep in that it will no longer be limited to one worker to come and establish that UK presence. Under this route, it's predicted that there will be a maximum of up to 5 UK expansion workers who will be permitted to come. And this will be 1 senior executive and up to 4 team members. So this is quite different to the sole rep, where there's only 1 worker allowed. There are a lot of questions still to be answered. For example, if this is a sponsored route, which the Home Office has said it is, how can a UK expansion worker be sponsored if there is not yet a company to sponsor them? Will it be that the senior executive is the only one who requires sponsorship initially, or will the team members also require sponsorship? This has been a recommendation from the Migration Advisory Committee, who advises the Home Office. Does the UK branch need to apply for a sponsor license? And if so, what kind of requirements must they meet to apply for the sponsor license? So moving on to the scale-up route. Again, this is aimed to open in the spring. We don't know the exact date. The USP of this route is that it allows the employment of highly skilled migrant workers without sponsoring them. There is strict criteria for businesses to qualify as scale-ups. I will touch on this. And essentially, this route is aimed to provide small to medium-sized enterprises with a simpler and streamlined process to quickly grow their business with those specialist overseas workers. There will be an opportunity to settle on this route, subject to specific requirements. And after 6 months of holding this visa, scale-up visa holders will be able to switch jobs or employers. So for businesses, they must show that in a 3-year period, their annual revenue or employment growth rate is greater than 20%. We don't know yet whether this is the immediate 3-year period prior, or can it be an historic period. We don't know if there's a minimum revenue threshold. At the start of the 3-year period, there needs to have been a minimum of 10 employees. For the actual visa applicant, there will be an English language requirement, and they must have a job offer from a recognized scale-up business. The minimum annual salary is higher than with the skilled worker, and it's $33,000 per year, which is quite significantly higher than with the skilled worker's minimum threshold of $25,600. So with the scale-up route, some of the pros are that it could provide a quicker route to settlement. It's been published by the Home Office that it could be 3 years as opposed to 5 years on the skilled worker route. There will be a fast track verification process for businesses to qualify as scale-ups. This will be faster than the sponsor license application, which currently is taking up to 8 weeks to be processed. There is, as you know, priority service with the sponsor license application, but these are capped at 10 requests per day. So with the scale-ups, it might be quicker to get that sponsor status. A few of the negatives are the minimum salary threshold is higher than the skilled worker, which for IT companies, this doesn't seem viable when under the skilled worker route. Tech roles are mostly on the shortage occupation list, meaning they can be paid much less than this $33,000 per year. they may have to apply for a sponsor license, which with that comes the attached record keeping and reporting duties. There is that minimum trading requirement of 3 years, which will limit the eligible businesses. And now Monica will be touching on the high potential individual route.
Sorry, I was on mute. So this is the category we know the least about, but it's really for these top geniuses that are showing high potential. The high talent visa, which has been around for some time for the exceptional talent, has actually been very little take up. So this is people that are graduating from top universities and we don't know what the criteria is apart from that, whether they have to show that they've achieved something or been involved in other parts of the business. So we're looking at people perhaps at the beginning of their careers. The other issue is we do not know what who will fall within the top global university lists. If you currently look at the top global university lists, they've got predominant bias towards American universities, and it's quite interesting the universities that aren't on the list because of the criteria that are used to assess the universities, which is sometimes not all academic. Apparently, students want some life experience and nice accommodation, and that's one of the rating values. So this is where an individual, say from Stanford, can have no sponsorship and apply. He doesn't need to have he or she doesn't need to have a job offer, and they can switch between employers. So it's this real high talent, and this may cause some difficulty for employers. But if you're part of a global organisation, most organisations do already look at graduates and have graduate schemes and targeting students in their own jurisdiction. And if they're part of a global company, they will join at their local jurisdiction and then transfer out. So I think this was a kind of looking at the pandemic, all of the innovation that came out, both in technology, in the science. It's to try and keep or attract the UK to have that talent. Whether an employer wants somebody that's more entrepreneurial and may flit around is another matter. So this is the one where you might be getting applications saying, I've got the right to work because I'm a high potential individual. So at the moment you might have a criteria where they must have the right to work in the UK, and this would be one way they could get over it. Over to you, Rebecca, to talk about recent changes.
So there have been some recent changes to the Global Talent and Youth Mobility Scheme. So as you know, the Global Talent route is for those world leaders who make important contributions to their field. Recently, there has been a list of prestigious awards added, which give Global Talent visa applicants the opportunity to bypass the endorsement requirement and go ahead and apply for the visa. These include over 150 awards, such as the Booker Prize, a BAFTA, Nobel Prize. Additionally, the definition of qualifying academic and research roles has been expanded under the recent changes. With the Youth Mobility Scheme, which is that temporary visa scheme for young people aged 18 to 30 to come to the UK and work and live and do as they please. This is currently a scheme that works with 10 other countries, and now it's been announced that India will be added to this scheme. The date of when this will happen has not been confirmed, but what we do know is that it will operate on a ballot system, and unlike the other countries, there will be an additional requirement for the applicants to either hold a degree or have 3 years work experience. So there is some upcoming change happening with the innovator route. What is happening is the threshold for the business eligibility criteria is being lowered to those businesses who are innovative with high potential to grow and add value to the UK. Currently, the threshold is higher. The business must be innovative, viable, and scalable, and they must have evidence of this. They must have evidence of structured planning, potential to create jobs, and grow into global markets. There will be a fast-track endorsement process for those businesses that have advanced ideas. Those applicants who have been accepted onto the Department of International Trade's Global Entrepreneur Program are automatically eligible for the Innovator Visa. There will be a scrapping of the £50,000 investment funds requirement. This is when the endorsing body is satisfied that there are sufficient funds to grow the business. The restriction on undertaking work outside of the primary innovator business is being removed. So the Home Office is looking to completely digitize the immigration system. They're aiming to have done this by 2025, and as part of this, they're introducing the ETA, which is the Electronic Travel Authorization System. So this will essentially be the same as what the US has, where anyone traveling to the US has to pay for and apply for an ESTA, where you input where you're staying, and then it needs to be approved before you fly. This is what the UK will be implementing. It will be for both visa and non-visa nationals. Currently, there is a system for certain Middle Eastern countries, but now the ETA is going to be extended to all countries. We don't know when this will exactly happen, but it should be fully implemented by 2025. So during the pandemic, there's been multiple concessions implemented by the Home Office relating to immigration. So I'm going to update you on a few of the recent developments. So firstly, what happens when your visa application center in your country is closed, a little bit on the Tier 1 entrepreneur job creation requirement, the startup visa, getting an additional 12 months, getting a replacement vignette to enter the UK, what to do if your endorsement expires on certain routes, and what to do if your indefinite leave has lapsed. So if you are applying for a visa and your visa application center closes due to COVID, you can attend a biometric appointment in any country, but you must have that permission to travel to that country. If you have submitted your application and then the visa application center closes, then you must unfortunately cancel your current application and pay for a new one. You will be refunded, but obviously that may impact cash flow for those sponsors. This end date of this concession has been extended to 31st of March. It may be extended again, we don't know. And next, the Tier 1 entrepreneur visa. So as you know, this route is closed to new applicants, but for those looking to extend, if their business has been disrupted by COVID, the requirement to employ at least 2 people for 12 consecutive months is temporarily scrapped. So these individuals may extend their visa for 2 years instead of 3, if they can show that COVID has disrupted their business. They will have to provide an explanation as to why they couldn't employ those staff members for consecutive 12 months. And extending the visa for 2 years as opposed to 3 may impact reaching the 5 years for ILR. Startup visa holders, again, if there's been disruption to the business caused by COVID, can apply for 12 months additional time in order to carry out their business plan. And the endorsing body must support this extension. They must provide a letter in support. They will assess the business, and they need to be satisfied that reasonable progress has been made. The visa requirements all need to be met again, and this concession will be in place until the 30th of September. So with the entry clearance visas, so those vignettes that are put in the passport and enable sponsored workers or visa applicants to enter the UK. Sometimes with COVID, travel is delayed, and so these vignettes will expire. What to do in that situation is you can apply for a replacement vignette. You can do this more than once. If COVID delays travel again. The fee is £154. However, the worker will need to attend a new biometric appointment. Additionally, when they come to the UK and they have to collect their BRP from the post office or from their sponsor's place of work, while COVID measures are still in place, they will not be penalized for failing to collect their BRP. So just briefly with these 3 routes, the global talent, startup, and innovator. As you probably know, they all require an endorsement. So normally if you must apply for the visa within 3 months of being awarded with the endorsement. If due to COVID you cannot apply within the 3 months, the applicants may still be eligible. They must provide an explanation as to why COVID prevented this application in time. It will be at the discretion of the Home Office, and it is assessed on a case-by-case basis. Lastly, with these concessions, the indefinite leave to remain or indefinite leave to enter. If you have one of these ILR or ILE, you must limit your absences, continuous absences, to under 2 years. So if you're outside the UK for more than 2 years, it will automatically lapse. The Home Office has implemented this concession. So if it lapsed on or after 24th of January 2020 and you couldn't return to the UK due to COVID, you are eligible to submit a returning resident application. You will have to explain in your application how COVID stopped you from returning to the UK. For example, provide evidence of borders being closed or flights being cancelled. And then once you're back in the UK as a returning resident, you can apply for your ILR to be reinstated. And now Monica will be touching briefly on right to work checks.
So I'm just going to give an overview of the basics before we talk about how they can be checked and the changes there. So as you know, an employer has a duty to do right to work checks. There's fines if they're not done, and even criminal penalties if you knowingly employ an illegal worker. So a right to work checks must be done prior to the candidate actually starting work for you. So and most employers have a good system in place, but if they forget it on their first day, they cannot do work for you. Some categories of workers, so such as those that are British citizens but not those, say, in dependent territory countries, or if they've got refugee status, or that they've got settled status, or indefinite leave to remain, you just have to do the check once, and that's good for the lifetime of the employment. But there will be follow-up right to work checks if they've got time limited right to work in the UK. So this is the pre-settled status, the point-based systems, those if you look at the current routes in, because of the war, family dependent visas, these will be ones that will need to be checked. You can either check online if you're given a share code, or check the worker's original documents. There is a movement towards checking them online, and Rebecca will talk about them. If a worker cannot provide a return to work documents, you're under an obligation to use the employer checking service, and you will be given a positive verification notice, and that provides a statutory excuse to 6 months, but you've got to be quite on top of it so that there's no time lapse. Sorry, Rebecca, you were right to move. So what needs to be checked? The documents are both genuine, unchanged, and belong to the person who provided them. They haven't expired. There's been quite a few people who have realised that the expiry date when they're going on holiday has been amended, and therefore they didn't have the requisite length on their passport to come back into the country, and we have seen that change because of Brexit. The photos and the date of births are all the same across the documents. Have they got the immigration permission to work for the job that they're applying for, and whether there's a limit on the number of hours they can work. This is particularly for students, so for their study and holiday times. And if there's any changes in the names across documents, evidence according, so marriage or divorce certificate or gender identity certificates. Rebecca's now going to talk about further the right to work checks.
Okay, so, sorry, the slide, there we go. So, as you know, as employers, sponsors, there has been adjusted right to work checks during the pandemic, essentially virtual right to work checks. And this end date for these adjusted checks has been delayed numerous times. But as of now, the Home Office is saying that the final end date will be the 30th of September. We're yet to see if that will be extended again. So currently, retrospective checks will not be required on those workers who had these adjusted checks between the beginning of the pandemic, so 30th of March 2020 and 30th of September 2022. This is provided that the adjusted checks were carried out properly, and I will touch on this next. So just a reminder of carrying out these adjusted checks. You must firstly request a digital copy of the original document you need to see via email. Once you receive these documents via email, you then review them and then arrange a video call with the worker. During the call, the worker should hold up the documents to their camera, which you must check against the copy you have digitally. If you're happy with the documents, you should make a note of this check stating the following: an adjusted check has been undertaken on this date due to COVID. With the online service, this is able to be used by biometric residence permit, so BRP, or biometric residence card holders, BRC holders. Those with pre-settled or settled status under the EU settlement scheme, and those who use the ID check app when they applied for the application. You cannot insist that a worker uses the online service, and you must still accept original documents and conduct manual checks. From the 6th of April, a new starter cannot use a BRP as evidence of their right to work. I will go into this. And they must provide a share code from the online service. An online right to work check is required for those individuals who have status under the EU settlement scheme if they began their employment on or after the 1st of July 2021. Share codes will always be 9 characters long, and they will begin with a W when they are used for proving your right to work. To use the online service, you will need the share code and the worker's date of birth. And conducting a right to work check via the online service gives you a defense against a civil penalty. So with BRPs, the Home Office has announced that from the 6th of April, you will no longer be permitted to do manual checks on BRPs. So this includes BRCs and frontier worker permits, meaning that new starters must use the online service, even if their BRP shows an expiry date later than the 6th of April. What this means is that up until the 5th of April, you can continue to conduct manual checks, and you cannot force BRP holders to use the online service. Now, with those BRP holders who have started work before the 6th of April, they will not have to have retrospective checks, so long as their initial right to work check was conducted properly. So this IDVT, so Identification Document Validation Technology, this is a new technology which will be implemented as part of right to work checks, and it will enable employers to carry out digital checks on British and Irish citizens. This will, as far as we know, this will not be a mandatory service, and employers will be able to opt in. They will be, if an employer wants to use this IDV technology, they will need to use a certified provider, so an IDSP, and they will act on behalf of the employer in carrying out the check. Obviously, there are implications with this. Who is ultimately responsible for carrying out the check if you're using a third party? Well, the Home Office has said that ultimately, as the employer, you are responsible for the right to work check. But if you carry out a check on a British or Irish national via a provider, a certified provider, you will maintain a statutory excuse against a civil penalty. You'll still be able to conduct manual checks on British Irish citizens, and this includes accepting expired passports as currently allowed. So that is what we will cover today. Does anyone have any questions?
I've got a couple that have come in, so I'll have the easy job. I'll ask you, Rebecca, and then you can answer them. So, are right to work checks required on EU employees whose employment began before the EU settlement scheme closed, which was in June of this year, of last year, rather, sorry?
So this is a popular question I get. When the EU settlement scheme closed, well, it's still open technically, but when it officially closed on the 30th of June last year, it was very confusing as to the right to work check process going forward. So what we definitely know now is that right to work checks are retrospective checks or follow-up checks are not required on those EU employees who started working on or before the 30th of June 2021. So you don't need to carry out follow-up checks on these individuals so long as you did a proper check beforehand. So what that would have been a manual check with a valid EU passport or national ID card.
Okay, and we've got another question. Then I think no more. So if anybody's got a question, type it away or let us know, or contact us afterwards. But the second question is, do you know whether the Home Office plans to keep the requirement for certain nationalities to register with the police? One of our Chinese-sponsored workers is struggling to book an appointment to register with the police as none are available.
So, due to COVID, I have been receiving feedback from our clients that police registration appointments are delayed significantly and there is a long waiting time. I've been in touch recently with the Home Office to clarify whether they intend to keep police registration appointments, and they have confirmed that they definitely do intend to keep them for certain nationalities. However, they will understand that there are delays in getting these appointments. So long as you keep trying to get an appointment, and if you get one that is 6 months from now, they should not be penalized for this, because this is out of their control.
And we have another question, which I will take. So the question is, with UK refugees, would their refugee status documents be allowed as evidence of return to work? So the answer is, if somebody has refugee status, the answer is yes. That is their automatic right to work check documents. You don't even need to check it again. I think that I reflect back that as a firm, we were really proud of the work that we did, lobbying with other organisations such as the CBI and working with the unions for the furlough scheme. And I think that there should be some kind of, again, this collective pressure to look at this aspect of the visa scheme. So I suspect that we're not very good at giving refugee status at all, and Rebecca will nod if she's in agreement here. But I do think that this other quicker routes will be hopefully coming in, which means that if you get, it may be on a fixed duration. So this idea of having 3 years where they can work, and that will just mean that that will be their right to work. You need to do that, and you might need to check in, as usual, before the 3 months deadline, an extension. So I think it's an evolving space, and for all of the wrong reasons, I hope we do have Eastern Europeans coming back into the UK in the numbers that they originally came, because some sectors have clearly missed them. I think, oh no, I've got some more questions. So if we used an IDSP, would we have to risk assess that provider, and would the Home Office ask for this risk assessment during an audit? Oh, that's a really good question. I don't know the answer, Rebecca, to that one.
So from the information that we have, these IDSPs will have to obtain certification through an organization or whatever it will be, who is approved by the Home Office. So so long as they are certified under Home Office standards, it will not be your responsibility to assess whether their certification is valid. You will have to use a certified provider. If you don't, then obviously you're at risk of enforcement action, but it won't be the employer's responsibility to assess the IDSP, so long as they're certified.
Is there a register of certified provider, or do they need to give you some evidence of it?
There will be a register, but I don't think that's available yet.
Yeah, so I hadn't seen that. So I think if you do your normal simple due diligence, which is copy of the certificate, company searches, those kind of things, that will give you some comfort. But I do expect that there will be a register where you can check, like, for other qualifications and such like. The last, they're all coming in now. They've all woken up, Rebecca. So next question. Just a sense check. If we have done a manual right to work check prior to the 6th of April for a person that is to start after the 6th of April, good, you'll start doing your check before. We should do this again using the government online portal with a share code? No, if you've done it the original documents, it's in either or. So you've well done. You're ahead of the game. You don't need to do that online portal. I'm just going to go and see what the next question is. Oh, so following on from that, where do we find a certified IDSP provider?
So this is something I don't know yet because it's not available. The Home Office has published limited information on these IDSPs. When they do publish the information, obviously I will share this if you have any questions. But as of now, we don't know who will actually carry out these IDV checks. This is something we don't know, and hopefully it will come out soon. I expect it will, seeing that it's March now, but as of now we don't know.
I would ask clients if they're using that kind of service, if you could provide us just feedback, because clearly we all know that you use providers that not only do the job, but the way that they do that job. So I think that information and that feedback loop would be quite good, just so, because I think it's a question that's going to be asked. I think that is it for questions. 2 minutes over time. Thank you very much for joining us. You know, Rebecca and I are around for the rest of the afternoon. If you've got any burning immigration questions, get in touch.
Thank you.
Thanks, Rebecca.